So we continue on with definitions. Last time we talked about an Indian. Now we're going to talk about the definition for an Indian child, and it's similar. It's an unmarried person under the age of 18 who is either a member of an Indian tribe or is eligible for membership in an Indian tribe. Now, this does not require enrollment, and enrollment is often kind of the gold standard. You'll go into court and you'll hear people say, well, are they enrolled in a tribe? They don't have to be enrolled in a tribe. All they have to be is a member. And then the question becomes, who defines membership? Well, that raises many interesting issues. The tribe is the arbiter of membership. The tribe is the only person who can tell you if someone is a member of a tribe. You know, I can't tell you if person A over here is a tribal member. Only the tribe can tell you that. So one of the things that's really important to do right up front in any ICWA case is to contact the tribe. You have to give notice to the tribe. You have to talk to the tribe. If you don't, everything you do is going to come to a screeching halt. I once spent 3 days in a court hearing, 3 days, where they argued about whether or not a child was an Indian child. They spent 3 days talking about that. The tribe appeared. The tribe said, yeah, this is an Indian child. And yet they still fought about it. They said, no, the child's not an Indian child. What I think finally convinced the court was when we pointed out that the child's grandmother's name was Buffalo Head. Now, there are many interesting names, but Buffalo Head is almost always a uniquely Indian name. And if a child is named Buffalo Head, more than likely or not, they may fall within a membership classification of a tribe. Sometimes not, but the only way to determine that is by asking the tribe. Membership is a function that is determined by the tribe, and it is a broader term than enrollment. Now, when you define an Indian tribe, you have to define a tribe, band, nation, or organized group that receives services from the Secretary of the Interior because of their status as Indians. This does not include unrecognized tribes. This does not include state organizations. When you talk about, for instance, the Cherokee Nation of Southwest Missouri and Northwest Arkansas, not to be confused with the Cherokee Nation of Northwest Arkansas and Southwest Missouri. They schismed. When you talk about those, you're talking about what amounts to social groups, what amount to just a bunch of people who want to pretend that they're Indian. They do not receive services from the Department of Interior, therefore they are not eligible for membership in the Indian Child Welfare Act. What's interesting are the groups that do not, that have absolutely no relationship to these pretend Indians, but who still fall outside of the protections of ICWA. Some of those are tribes from Mexico and Canada, although there's an act from 1789 called the Jay Treaty, the Jay Treaty of 1789. And it says that there are some of the tribes kind of on the northeastern side of the country that may go back and forth across the Canadian-American border, and those tribes will fit within the qualifications of ICWA. Jay Treaty, 1789, still valid law. One of the most interesting groups to fall within these protections that don't fall within the Indian Child Welfare Act would be Native Hawaiians. Now, Native Hawaiians had their own country until we took it over. They had a queen, they had a representative form of government, they had their own land base, And we decided that we could make better use of it for sugar and pineapples, and Hawaii was conquered, basically. Not to put too fine of a point on it, but we simply seized it. And now we have an interesting situation where Native Hawaiians are the only indigenous group in our nation that are not counted as something that would fall under the Indian Child Welfare Act or something that would fall under protections for the Department of Interior. But that could be changed. In the next year or two, you are likely to see a new representative government of Native Hawaiians be formed in Hawaii, and depending upon how the election goes, you may well see Native Hawaiians falling under the protections of the Indian Child Welfare Act very shortly. Now, determining if a child is an Indian child is a prerequisite to the Act, and we see that in these provisions. 23 CFR 23-107. The question is asked in the regulations, how should a state court determine if there is reason to know a child is an Indian child? Well, this is kind of a tough one, but believe it or not, it's often a problem. State courts must ask each participant if the child is an Indian child. That sounds so obvious, that sounds so clear, but yet it is so often not done. The first thing a judge should do when it's facing a new case is say, is this child an Indian child? And if the answer is, I don't know, the response of the court should be, find out. And the reason for that is that if a child is a member of an Indian tribe, and the Indian Child Welfare Act does apply, anything you do without following the Indian Child Welfare Act is going to come back later, and you're going to have to do it all over again. So it's really important from a judicial economy viewpoint that judges ask this question: is a person an Indian child? If there's reason to know that a person's an Indian child, but there's not sufficient evidence, like the tribe hasn't shown up and somebody saying, yes, this child is an Indian child, then the court must confirm this by asking the tribe. The court must treat the child as an Indian child. Now, once the court has asked somebody if they're an Indian child, they have a further obligation to make sure that everybody is on the same page with this. 23-107C says, a court upon conducting the inquiry, required in paragraph A, has reason to know that a child involved is an Indian child if somebody says, yes, this is an Indian child. If a participant says, we have information that says that the child's an Indian child. If the child says, yeah, I'm an Indian child. And finally, if there's a domicile or residence of the child on a reservation or an Alaska Native village. Now, let's consider Oklahoma for just a minute. Is there a court anywhere in the state of Oklahoma that does not have at least this first initial reason to ask if a child is an Indian child? Oklahoma doesn't have reservations. Oklahoma was a reservation. So any juvenile proceeding in Oklahoma should begin with the judge saying, does anyone know if this child is an Indian child? You have to ask. Now, you are going to have a lot of, shall we say, using a computer term, you'd have a lot of noise in this request. If you say someone's an Indian child, someone's going to say, almost inevitably, well, their grandma was a Cherokee, or their grandma, I'm pretty sure their grandma was Indian. There's going to be a lot of these broad statements, but you still have to ask, because grandma may really have been a Cherokee. Grandma may be a member of the tribe and the child may be eligible in that tribe. You can't determine based on what may happen. You have to ask. You have to make that inquiry. And if the court fails to make that inquiry, it is a problem. Okay, now, Section D of 23107 requires the court in a voluntary proceeding where a parent is giving up parental rights. That doesn't excuse the court from asking if the child's an Indian child. And the court must keep relevant documents pertaining to the inquiry, and they can go forward and find this information. That's even if the parent asks that this be kept quiet, that this be an anonymous proceeding. The court still has an obligation to ask if the child's an Indian child. There's no way to get around the Indian Child Welfare Act. You must provide that information. Now, as I said, membership doesn't require enrollment. It's a really flexible term. It's broader than tribal enrollment or even Certificate Degree of Indian Blood, CDIB cards. The tribe is the ultimate and only party who can claim if a person is a member or an enrolled member of the tribe. They are the only ones. And we see this in 23108, 23 CFR, section 23108. The question is, who makes the determination as to whether a child is a member, whether a child is eligible for membership, and whether a biological parent is a member of a tribe? And the answer to that is the Indian tribe. Now, the determination by that tribe if they're a member is solely within the jurisdiction of the tribe, and the state court must follow that recommendation. The regulations require that. Now, should a state court determine an Indian child's tribe is eligible in more than one tribe, an Indian child is eligible in more than one tribe, the state court must ask all of the tribes. And in 23 section 109, we see the regulations want the tribes to come together and sort of figure out who will be the main tribe. If the tribes are unable to reach an agreement, if the tribes are unable to determine who should be the main tribe speaking for the child, then the court in that one situation, that one instance, gets to decide who's going to be the tribal representative in that case. Now, the reverse also is applicable. If a tribe says a person is not a member, the court cannot apply the Indian Child Welfare Act. The act would simply not be applicable there. When we go on with definitions, we can talk about parent. That's pretty easy. A biological parent or parents of an Indian child, or even a parent who has been lawfully adopted, but it does not include an unwed father who has not been determined through paternity. All biological parents are included in this term. You do not have to be Indian to invoke the Indian Child Welfare Act. You have to be the parent of an Indian child. So you can be a non-Indian person but still fall within the protections of the ICWA. You would still have the same degree of protection as an Indian parent. Indian custodian means an Indian person who has legal custody of a child under tribal law or custom or under state law or custom. Let's talk a little bit about state law. If you are an Indian parent, and if you are the parent of an Indian child, and you give your child in, say, a guardianship to an Indian grandparent, that grandparent then becomes an Indian custodian, and they have certain rights. This is the only time where the Indian Child Welfare Act actually delves into the Indian status of a parent being key. So a custodian, an Indian custodian, is going to have certain rights under the Act. But a non-Indian custodian, a non-Indian guardianship, for instance, is not going to have those protections. So a guardian who is an Indian falls under the Act. A guardian who is non-Indian does not fall within the protections. Now, reservation is Indian country defined in Section 1151 of Title 18. Now, in Oklahoma, Indian country is trust land and it is restricted land. Those are where that's kind of the basis for jurisdiction in this country, in this state. So, for instance, if a child lives on trust land, the protections of 1911A are going to apply. If a child lives outside of trust or restricted land, then the protections of 1911B are going to apply. That concludes our definitions. Now, the next thing we're going to talk about is what happens when children live on trust land versus what happens when children live on non-trust or restricted land.